2007.
कोई केस बताए ना?
जी, this is mentioned, my lord, this is it mentioned in Samiullah Baloch.
नहीं,
For example, 2007 Supreme Court, this is what is quoted there.
2007
Supreme Court, PLD 2007 Supreme Court 369. Imtiaz Ahmad Lali versus Ghulam Muhammad Lali.
This declaration part was interpreted in 1985.
Hello?
ये जो 62(1)(f) की अमेंडमेंट पहली दफा कब हुई है?
62(1)(f) की तो अब वो पहले भी होती रही है,
हुई है ना?
पहले भी होती रही है, बट ये जो डिक्लेरेशन बाय कोर्ट वाला वो अब आया
18th अमेंडमेंट में आई है ना
जी, ये 18th अमेंडमेंट
2010
अप्रैल 2010।
आप जजमेंट्स दे रहे हैं हमसे उससे पहले की।
मैं ये कह रहा हूँ जी कि उस 18th अमेंडमेंट जब पार्लियामेंट एनैक्ट करने बैठी तो पार्लियामेंट इज प्रिज्यूम्ड टू नो द स्टेट ऑफ केस लॉ, दैट्स अ प्रिजम्पशन. They knew that 62(1)(f) has been interpreted in this manner. They knew that there is a presumption. They consciously made changes in various articles of 63, but did not make changes.
Where are you getting this presumption from?
Well, this is settled.
Judges don't know sometimes what the law early judgments are, and the parliamentarians are expected to know what the judgments are.
But your lordship is wearing all the laws of the country on the sleeves of your lordship's robes. That's it.
I don't profess that.
That's the law of the country.
ये जरा क्लियर कर दें कि 2010 से पहले what was the language?
2010 से पहले 60.
Because those judgments that you're relying on, उसमें life की बात.
He is sagacious, righteous, and non-profligate and honest and mean. That's it.
That's it. And this was interpreted to be a lifetime ban.
This was interpreted to be a lifetime ban.
देखिए एक चीज है ना, there's another, Khurram Saab has drawn a distinction between 62 and 63, and 62 is the entry gate according to him. So this entry gate does not open to you if you're not honest, sagacious, non-profligate, entry gate according to him. So this entry gate does not open to you if you're not honest, sagacious, non-profligate, according to him. So this entry gate does not open to you if you're not honest, sagacious, non-profligate, according to him. So this entry gate does not open to you if you're not honest, sagacious, non-profligate, according to him. So this
Judgments for a lifetime ban?
That simply because the Constitution
read one of them.
Did not.
हम आपके साथ पढ़ना चाहते हैं.
जी, if I can just answer this, that there was no time limit given in the Constitution in contradistinction to some other.
And where did they draw the disqualification at that time from? Because there was no declaration of any court of law.
There was no declaration.
So how would they?
What was happening at that stage, my lord, was that even the ROs were rejecting
ask a
papers,
question.
asking questions. ROs were in their summary inquiry.
Mr. आप अपना point बताएं. आप अपना point बताएं.
नहीं, अभी तो मैं सिर्फ आपको historical background दे रहा हूँ. My point, जी, my lord.
किस तरह से देखते हैं कि 62(1)(a) को देखते हैं. There is a declaration he is not a citizen of Pakistan.
जी.
Thereafter he becomes a citizen of
My lord.
तो वो भी permanent disqualification as per Samiullah case.
My lord, if I can, I was going to proceed step by step, but let me say this. The way I read Samiullah Baloch, I don't see it as laying down a permanent disqualification. It only lays down, in my humble reading, an indefinite disqualification. And that can come to an end. The problem with Samiullah Baloch is it doesn't discuss the mechanism for that. And I will be making submissions on that. So, that's why I'm saying that for me, Samiullah Baloch, I can just state my view on this. Samiullah Baloch need not be overruled, but there are problems with it which can be fixed. I don't see it as laying down a permanent disqualification, but as an indefinite disqualification, and that indefinite disqualification can come to an end. The problem is Samiullah Baloch doesn't deal with that mechanism. I will make some submissions on that, and those are for your lordship.
Tell me, this is a new novel point.
My lord. But I will, because I'm here in a neutral capacity,
yes.
I will also make submissions on what happens if your lordships choose to overrule Samiullah Baloch. My lord. Well, the point, the historical context, the other point is that subsequent to the 18th Amendment also, there have been various constitutional amendments. We have 25 or 26 now. And this, despite the fact that the court's unease with this lifetime ban was evident in 2018 and onwards, no constitutional amendment ever chose to deal with this issue. Even though this was something, the disqualification of politicians or those running for a parliamentary office is something that affected Parliament directly. But nonetheless, the Parliament chose not to deal with it. So, my lord,
could it be because एक वो उन्होंने लैंग्वेज चेंज कर दी थी वो ओथ में, तो पूरा पाकिस्तान को बंद कर दिया, तो हो सकता है उन्होंने कहा इसको छोड़ ही दें, ये भी तो हो सकता है ना, क्योंकि लोग जो बोलते हैं ना what word should be used for them who don't want to follow the legal or constitutional path but want to impose their will on the state. So, but the state is still cognizant of the fact that who will deal with these people.
My lord, if one could go back in time, one could want to change a lot of things. As Ghalib said, वो हर एक बात पे कहना कि यूं होता तो क्या होता, we don't know कि क्या होता. We are stuck with the letter of the law, right? What as it is, and we have to deal with that. Whether that is how it came about. So my lord,
हम आपसे सुनना चाहते हैं कि अब होगा तो कैसे होगा?
My lord, yes. I mean, I don't think a lifetime ban ought to be there, frankly, and I don't think the way I read it, Samiullah
be there or should not be there?
Should not be there. It should not be there. But I don't think the way I read it, Samiullah from my submissions to find a way out from. It should not be there on the basis of Samiullah Baloch, and I'll say that. And I don't think that Parliament chose not to deal with this issue through the 18th Amendment is actually considered in Samiullah Baloch itself. Your Lordships may just note paras 17 and 23. Para 17 at 432 and para 23 at 436. And it becomes actually very clear from para 9 of Justice Azmat Saeed's separate note. Very clearly says in what he's written in para 9. So this is the key. My lord, my submission is, what has Samiullah Baloch actually done? It has interpreted these words, and my lord the Chief Justice asked this question, what do these words mean? There being no declaration to the contrary by a court of law. What Samiullah Baloch has done is that it has linked the disqualification to the declaration by the court, and extrapolated from that since the basis of the disqualification or lack of qualification is the declaration by the court, therefore it should be coterminous with the decree itself, the declaration by the court itself. So long as the decree continues, the judgment continues, the disqualification continues. So if there is some way to end the effect of the decree, the disqualification will also end. That's the logical consequence. Samiullah Baloch in para 35 alludes to this, touches upon this, but then doesn't really go on and explain this. So, my lord, so I will come back to this, but one point, as I said, your lordships are sitting in a larger bench. Your lordships can obviously revisit Samiullah Baloch. Should it be revisited? My lord, the argument for its overruling or revisiting it is weighty. I don't dispute that. But in my humble opinion, even without overruling Samiullah Baloch, a way out can be found. And why do I say that, my lord? Why do I say that Samiullah Baloch should not be overruled? My lord, the prime argument that I am aware of, and I heard bits and pieces during the live broadcast a day ago, was that 62.1F should be read along with 63.1H. And reading them, this seems to be the main argument. This argument was considered in Samiullah Baloch in great detail in paras 27 to 32, pages 438 to 442. And they said that it was held that these two are separate. Qualifications and disqualifications are separate and we can't use them. An expression that I have used earlier also before, my lord, is that in my view they are like Siamese twins. Siamese twins are joined at the hip, so they are one for many purposes, but actually they are two separate persons, two separate entities. So they are separate for some purposes and they are joint for some purposes. For example, Your Lordship, the Article 100 of the Constitution talks about the qualifications for the Attorney General, and those have been interpreted, Article 100 has been interpreted to mean that only the qualifications given in Article 62 shall apply, or for the qualifications required of a judge of the Supreme Court in that case will apply, and not the disqualifications. My lord, in Rafiq Tarad's case, PLD 1998, Lahore 461,
PLD
1998, Lahore 461, it was a full bench decision of the Lahore High Court. Just note, I'm not, there the question was that Article 41 says the President has to have the qualifications for a same qualifications as Member of Parliament. And the question was whether the disqualifications mentioned in Article 63 will also be applicable. And it was held by the full bench that because the word qualifications is used, only Article 62 will apply and Article 63 will not apply. So there is a conceptual difference between the two, but for certain matters they have to be read together, but not always. So my lord, my submission is that this argument that 62(1)(f) should be read together with 63(1)(h) and draw its inspiration in terms of the duration from 63(1)(h) was considered and was not accepted. Since it relied on earlier judgments starting from the 1960s, hence, since it has been there for a long time, there are many precedents for it, therefore, in my humble opinion, it should not be overruled. My lord, I'll just place 2-3 judgments on that before you.
आप हमें अपना बता देना.
जी, मैं तो अपना बता रहा हूँ.
When you say it should not be overruled, we observe number of judgments have been cited, including Faisal Wawda, same learned judge, not following Samula Baloch.
My lord, I will. When I come to this way out, I will rely on Faisal Wawda. I think it is it explains.
Well, how do you reconcile the two?
My lord, they will be reconciled. They are not.
Can you reconcile the two?
My lord, I will make submission on that. I think.
कर देना.
वो तो आखिरी पॉइंट
नहीं आखिरी नहीं, देखिए हमें थोड़ा सा स्पीड अप करें ना
पहले. My lord, वो फिर मैं अपने नोट्स के आखिरी पेज
नहीं आप आ जाएं
My lord,
कोई हमें और लोगों को भी सुनना है ना.
नहीं मैं बिल्कुल जी, मुझे तो खुद
आप लाहौर नहीं जा सकेंगे
सर. मैं आज लाहौर में गया तो जी मैं लाहौर शायद कभी भी नहीं जा सकूंगा. Let's put it that
ये भी हो सकता है.
So इसलिए मुझे प्लीज आज जाने.
Let me try another way. Motorway closes at 3:30. Motorway closes at 3:30.
चले जल्दी बताए ना.
My lord, I'll finish in 20 minutes.
चले हाँ.
My lord, for me, the key to this issue, and I'm sort of jumping to the last page of my argument. My lord, the key to this
अगर आपने लिखा हुआ है वो हम पढ़ लेंगे.
My lord, वो मैंने अपने लिए अभी मैं आपको दे दूंगा. मैं एक आध दिन में आपको भैया तो मैंने गाड़ी में कल टाइप किया जी, बिकॉज़ टाइम नहीं था मेरे पास. My lord, the key for me to resolving this issue really is in para 6 of some
same judgment
of the Baloch.
जी पढ़े.
A point which was put before the court, but then the court
तौबा कॉन्सेप्ट. हाँ वो डिस्कस किया, आगे जवाब नहीं उसका.
नहीं है वो, इसलिए कि उन्होंने कह दिया. And what they have said there, the reason they did not consider it, my lord, is also significant. He was, however, candid to accept, and the court is dealing with Sadar Aslam's submissions here. He was, however, candid to accept that except for submitting their affidavits in court, his clients had not made any expression of remorse, regret or repentance before the concerned authorities or the public. And the question arises, what would have happened if that had been done? The way out, as I see it, and which something Samula Baloch doesn't deal with, is exactly because of this. This is established that there is genuine repentance, there is, and penance has been paid, then the effect of the declaration can come to an end. And
Then again, we are reading words into the Constitution.
my lord, that is something, my lord, it's a question of interpretation. It is a question of interpretation, and my lord,
I
justice.
earlier posed a question. If I was the author of Imagine, it's not been written yet, Samula Baloch, and I'm hearing it for the first time, and I said it should be a 2-year ban. So it's entirely up to me what I do.
My lord, I'm not saying that there should be a fixed plan. That's exactly
No,
what I'm saying.
I'm just saying कि what is the test before me? It's not because Samula Baloch has held this. That's the end of story.
No,
There
fine.
must be a logical reasoning behind it, reaching that conclusion. I say, if that is 5 years, I do 5 years. Or I say, that is much more serious, I do 2 years. So it's entirely my discretion,
But I'm not saying-
unguided by any legal concept or constitution.
I'm not in favor of that at all.
I'm
I'm not
asking you,
advocating that.
so it would be as valid, Baloch.
No, my lord, I'm not saying that. I'm not saying that. I am not saying that the judges should have a carte blanche to write whatever they want. Whatever they write has to be
Guiding
based.
principle बताइए ना हमें.
So,
The guiding principle-
Mr. Uzair, your principle is that one principle or way out is that if there is a declaration, it can be washed away through penance and repentance immediately, whenever given. So if the declaration is given today, in 1 hour I submit an affidavit of repentance, the matter comes to an end, or is there a time frame?
No, my,
for that?
no, my lord, no, my lord.
How would
I
that
think
work?
As they say, my lord, the devil is always in the details. My lord, 62(1)(f) encapsulates 5 different concepts. Like, for example, there is a requirement that the candidate be non-profligate. Now, profligacy, the simple meaning is, spendthrift. You wasteful of resources.
Yes.
No.
Now, that's something that's probably
No,
easier to
suppose the
fix.
declaration is that there was a misdeclaration in a form which has left the declaration, then there is no direct declaration in any case. We're assuming that the declaration is that you're not honest because you're... So next day he comes and says, I'm very sorry, this will never happen again, sir. I'll never misdeclare ever. And he's repented. What else would you want him to do?
My lord, because the first, I don't agree with what your lordship has said in the first part of your statement. The fact that there is a form and there is something wrong with that is not enough. That is not enough to
That's
disqualify
all
him.
that's happening in all these cases.
No.
There is no declaration. The declaration is based on a construction. It says that the form is incorrect, the assets form is not incorrect, you've left out this paragraph, you've done this, that's all there is that they discover. And then they build it on that. They say, because this is omitted, you are not a mean. That's the declaration in every case.
But we are, your lordships and your ladyship are here precisely to see whether that's right or not.
No, so that's,
And I'm saying
then that's a separate...
That's not.
Are here
No.
to see, but to
That's
be
not.
assisted by you.
Mr.
Well,
Uzair,
that's
then
what-
that's a separate basket of questions. A separate...
That's not-
Then,
Here to
whether
see,
at
but
all
to
in
be
any of these
assisted by
cases
you.
so far till date, is there a declaration looking straight into your eyes saying you're not honest because of the following issues? No, it's not. Nobody's saying that. One is just building, and that's what Samuel Baloch also says. You'll have to construe from the facts and you say that you're not
My
honest.
lord, इसीलिए मैंने कहा था कि वो आप मुझे page 6 पे ले गए मेरे notes के. If I had gone
चले,
through pages 2, 3 and 4, maybe I would have been able to make some submissions on
बताएं ना अपने
that.
points.
My lord, I am very clear that merely because somebody finds that I haven't dotted all I's and crossed all T's in my nomination form, I am dishonest. I am not saying that is correct.
ends the matter.
That's wrong. That's wrong.
Then
That's
in that
merely-
case, Mr. Uzair, there is no declaration ever
The
so
point-
far in any
no,
case.
But the point is, what is the declaration to the contrary by a court of law that 62(1)(f) contemplates? Where does that come from? And that's, I will make some submissions on that. For me, that's a formal process that has to be followed. It's not something that the RO can do. It's not something that the election tribunal hearing appeals against acceptance and rejection of nomination papers
Or a
can do.
constitutional court.
Constitutional court can do it. There is your lordship's judgment in 2010.
There could be mistakes made, but the question is
My lord, that is not a
right?
mistake. That's a conscious judgment by my lord, and I rely on it. And that's absolutely correct.
I'm not noting anything.
My lord, so what I'm saying is, my lord, my submission was that for me, the way out is provided by the logic, the rationale of Samuel Baloch itself. Samuel Baloch is deficient because it doesn't follow through with the consequences of its own logic. For example, so that's the problem. And if that gap can be filled, then there is no need to overrule Samiullah Baloch. Samiullah Baloch is a judgment
Mr.
of...
Uzair, on that point, that's why you want to take it forward. You said the Samiullah Baloch gives an answer in paragraph 6 that there should be repentance, but it doesn't talk about it.
It touches
And
upon
I asked you that how do we follow through? Then you say, no, there is no declaration. So please tell us, the declaration is just the way it is. When does the repentance kick in and how do you bring that in?
There are two stages. First, there will be a declaration by a court. There will be a declaration by the court, and that declaration would be for the purposes of 62(1)(f). One problem with Samiullah Baloch is that it doesn't really deal with what a court, what proceedings, what nature of dispute would lead to this declaration.
Mr. Bhandari, in paragraph 36 of the Samiullah, there is a word declaratory judgment. The declaratory judgment, what is the declaratory judgment? By the civil court or the high court or the Supreme Court?
My lord, it is, and I heard submissions on that also, my own submission, and I'm guided by my lord's judgment in 2010 Lahore. This is not a declaration in terms of section 42 specific relief act. It's a constitutional declaration. It is not shackled by the constraints of section 42 specific relief act. It is, and this is not the first time that the constitution has provided for it. Kindly look at article
How
181.
to give the declaratory judgment unless you examine and cross-examine
Yes.
and produce, allow to production of evidence?
Absolutely.
How you can reach to the declaration?
That has to be done. It can't be done without that.
लेकिन आप कहते हैं कि अगर वो deficiencies, if we give any detail of those deficiencies, वो पूरी कर ले तो फिर वो ठीक है लाइफ बैन?
नहीं, मैं तो कह रहा हूँ लाइफ बैन है ही नहीं, वो लाइफ बैन है ही नहीं, क्योंकि अगर आप रिपेंटेंस कर ले, अलाउ मी टू सबमिट माय लॉर्ड, और समीउल्लाह बलोच ने ये डिस्कस किया है कि कॉन्स्टिट्यूशन में और भी सिचुएशंस हैं जहां डिस्क्वालिफिकेशन कोर्ट की जजमेंट से फ्लो कर रही है, और कहा है कि जी वहां भी यही है कि जब तक वो कोर्ट की जजमेंट इफेक्टिव रहेगी तब तक डिस्क्वालिफिकेशन रहेगी. फॉर एग्जांपल 63(1)(a), 63(1)(b, तो 63 जब कोर्ट की डिक्लेरेशन सेक्शन 45 मेंटल हेल्थ ऑर्डिनेंस का कहता है कि अगर कोई पहले डिक्लेयर हुआ है एज मेंटली डिसेबल्ड, अगर वो ठीक हो जाता है तो कोर्ट अपने ऑर्डर वापस ले सकती है, तो वो डिस्क्वालिफिकेशन खत्म हो गई. सेक्शन 63(1)(b) अनडिस्चार्ज इंसॉल्वेंट को डिस्क्वालीफाई करता है, बट सेक्शन 41 ऑफ द इंसॉल्वेंसी एक्ट
आगे बढ़े
जी वो डिस्चार्ज का प्रोविजन देते हैं. बट आप क्या सर, इन रिस्पॉन्स टू माय लॉर्ड्स क्वेश्चन, काइंडली सी आर्टिकल 184(1) and 2. Article 184(1) says the Supreme Court shall, to the exclusion of every other court, have original jurisdiction.
उसके लिए है ना declaratory judgment. It is with regard to the provinces and the federation.
Yes, but kindly read 184(2). In exercise of the jurisdiction conferred on it by clause 1, the Supreme Court shall pronounce declaratory judgments only. So this is a declaration created by the Constitution. This is not subject to any law. No law is required, nor can any law change this. This is a declaratory relief, a remedy created by the Constitution itself. And by definition, my lord, the declaration envisaged by 62(1)(f) cannot be given under section 42 unless you expand section 42. For example, it says,
but this declaratory judgment is only in the context of clause 1 of
के लिए है, तो शुभों के लिए है.
अगर आपका आर्ग्यूमेंट चले, हम आगे नहीं, एक सेकंड ठहरिए ना, आपने 184(2) का एग्जांपल दिया, तो आईन खुद तय्युन कर रहा है कि सुप्रीम कोर्ट डिक्लेरेटरी जजमेंट दे सकती है.
yes,
जरा ठहरिए ना, 62(1)(f) में आईन ये नहीं कह रहा है. 62 में लिख रहा है कोर्ट ऑफ लॉ, या तो आप कहें वो इम्प्लाइड है सुप्रीम कोर्ट एक्टिंग अंडर 184. इधर लिखने में क्या दुश्वारी थी?
मैं अर्ज कर देता हूँ.
ये तो सारी चीजें फिर अदालत ने की है ना, आईन ने तो नहीं की हैं.
अग्री. लेट मी जस्ट एक्सप्लेन कि मैं क्या कह रहा हूँ. पहली बात मैं ये कह रहा हूँ, क्योंकि ये आर्ग्यू भी हुआ कि जी ये, और आपने भी सवाल पूछा कि ये क्या डिक्लेरेटरी जजमेंट है. मैं ये कह रहा हूँ कि जी ये जो डिक्लेरेटरी जजमेंट्स का कॉन्सेप्ट कॉन्स्टिट्यूशन में है, ये सेक्शन 42 वाला नहीं है.
ठीक, यहाँ भी लिख देते.
नहीं सर, वो इसके अंदर है. मैं आप अर्ज कर देता हूँ.
स्पेसिफिक है मिस्टर भंडारी.
मैं ये कह रहा हूँ कि ये जो है, ये डिक्लेरेशन ये सेक्शन 42 में दी भी नहीं जा सकती, आपकी अपनी जजमेंट है।
अरे वो मान ली बात,
नेगेटिव, ये तो नेगेटिव डिक्लेरेशन है।
हाँ,
There being no judgment to the contrary, so the declaratory judgment has to say that someone is not honest, someone is not.
So where do you draw the strength from that? कहाँ से कॉन्स्टिट्यूशन में लिखा है कि ऐसी डिक्लेरेशन दे सकते?
नहीं, मैं तो कह रहा हूँ कि ये पहली, my point number 1 is that this is a unique kind of declaration which is not given in terms of section 42.
मैं तो ये कह रहा हूँ, ये
अगला सवाल आता है forum.
एक एग्जांपल, अब आपको एक एग्जांपल दे देता हूँ। एक केस है सिविल केस, ठीक है, या क्रिमिनल केस ले लीजिए। एक गवाह आकर के झूठ बोलता है, कोर्ट उसको परजुरी के तहत उसको कन्विक्ट कर देती है, परजुरी के तहत। Is he disqualified for? It's a declaration now. You are a perjurer. You have lied in court on oath. You can't possibly be honest. So he's not allowed to contest elections for life. इसका जवाब दे दें।
Well, मेरे ख्याल में तो he's not disqualified on that basis.
तो फिर तो it will directly conflict. खत्म हो जाती बात।
Because आप जब किसी को perjury के, देखिए
तो declaration हो गया ना, कोर्ट ने उसको convict भी कर दिया।
तो मैं जवाब
सुप्रीम कोर्ट ने uphold भी कर दिया। चलिए।
मैं आपको जवाब देता हूँ। आर्टिकल 10 है, उसका जवाब है। वो कैसे? Let me explain. Article 10 says there will be due process and fair trial. An elementary principle of due process and fair trial is notice of the charge against you. Now, when somebody is being tried for perjury, is he under notice that he will also be disqualified on 62(1)(f?
So then that sort of kills the whole thing. So, आपके मुताबिक 62(1)(f की declaration कहाँ से आ रही है पहले?
मैं आपको
just explain that.
वो कई स्टेजेस पे, कई फॉरम्स पे आ सकती है। स्टेप नंबर 1 बाय प्रोसेस ऑफ एक्सक्लूजन चलते हैं। सबसे पहले आरओ के पास नॉमिनेशन पेपर्स जाएंगे, वो नहीं दे सकता। It's not a court of law.
He has to be shown some declaration at that time from some court of law.
By some court of law, and that declaration has to be specific for the purposes of 62(1)(f).
वो कहाँ से, मतलब give us an example of that.
मैं चलता हूँ, हम स्टेप बाय स्टेप वो स्टेजेस के थ्रू जाएंगे, शायद मेरी बात क्लियर हो जाएगी। The fact कि आरओ नहीं दे सकता has already been held by this court in Aladino's Bhaios case, PLD 2020, Supreme Court 591।
अभी वो नोट किया था
जी, ठीक है। नेक्स्ट स्टेज, आरओ ने फैसला किया, अब हम इलेक्शन अपील में चले गए। आर्ग्यूबली, अब ये प्री इलेक्शन है, हम आरओ ने ये फैसला किया, इलेक्शन अपील में हम आ गए। अब इलेक्शन अपील अंडर सेक्शन 63 of the Elections Act, election tribunals comprise generally of sitting judges of the High Court. So they are judges, but then acting as persona designata. So arguably, if they have admitted facts before them, they have admissions, or they have undisputed facts before them, then they can make this declaration.
At best would be regarding the fact that yes, there was a mistake in filling the form. That's the message.
There can be something more than that. Something more than that. For example, an objection is filed that this gentleman has already been convicted for perjury. That's an objection taken before the election tribunal.
Convicted.
So that is when the election tribunal, if it is a court of law, can arguably make that determination that whether this conviction for perjury actually attracts.
हे पापा, इन लोगों की मेहनत का पसीना यहाँ जीना मुश्किल कर रहा है। क्या करें?
हर प्रॉब्लम के हल की डिलीवरी, नो प्रॉब्लम, डोंट वरी, फूड पैंडा संभाल लेगा।
नहीं हुआ
ये जो आपने सेकंड पॉइंट किया है, दैट इज एग्जैक्टली माय पॉइंट, कि जो कन्विक्शन है फॉर पर्जरी, दैट इटसेल्फ इज नॉट डिसाइसिव। वो तो कानून शहादत के नीचे भी डिसाइसिव नहीं है।
आपका कहना है, फिर तो आप कहिए ना कि समीउल्लाह बलोच इज रॉन्ग।
Samiullah Baloch doesn't deal with this issue. That's my point. The Samiullah Baloch doesn't deal with the issue of how, in what proceedings, by which forum will this declaration be given.
That's correct, ना कह रहे हैं wrong है।
मैं ये कह रहा हूँ it is deficient.
नहीं देखें ना,
That's why I'm saying it is deficient, because it does not deal with this critical issue.
That creates a problem. Samiullah Baloch says that disqualification is for life because of this very declaration by a court of law, and yet it does not deal with the fact that where is this declaration actually coming from.
Yes.
So it is very important to understand, because various councils are given a different viewpoint on this. Is it that when the nomination papers are filed, the RO will sit there, but somebody is going to produce a declaration from a court saying that this person is not sagacious, or will the RO start determining that question? So if it is to come from outside, some other court, फिर किसी court की declaration ये specific होगी ना that this person is not honest. Now I don't know of any declaration that can be possible under 42 which would say that he's not honest. तो मुझे ये पहले तो ये this conundrum तो solve ही नहीं हो रहा ना कि declaration आएगी कहाँ से?
ये 42 की declaration है।
अच्छा मैं एक और चीज कहता हूँ, मैं कहता हूँ declaration as envisaged under 62(1)(f cannot be legally passed. Hang on, now hear me out. First word in 62(1)(f) is it can never be passed. Now please chew over this concept. Sagacious. Which court of law can ever determine this? It cannot be passed. A declaration to the contrary, we are not the क्या कहते हैं जो Spanish Inquisition के जो court say, no court, unless you tell me yes, a court can pass such a declaration of sagacity. Can a court pass a declaration of righteousness? Can a court pass a declaration of non-profligateness, honesty, and Ameen? You cannot pass these declarations. I gave you a tangible example, even that you can't handle. I said, what about perjury, conviction of perjury? Which court? You said a court of law, a court of law. So I am now a civil judge and I say, you are not sagacious, Mr. Uzair Bhandari, because you misled me in that case. You cited a judgment of the High Court which was overruled by the Supreme Court. You are not an honest lawyer. Is that a declaration? So I am saying these are just words on a piece of paper which are utterly meaningless. What would you say to that?
My lord,
I'm just proposing this, not holding it, mind you.
My lord, actually, if your lord, since I am in that happy position that I mentioned, I agree with your lordship. These are not enforceable standards. These are given in the constitution.
So the problem we're facing.
So as, my lord, as a citizen and as somebody who knows something about politics and constitution, for me these are completely amorphous, subjective, vague concepts which are not judicially enforceable. But we have to give some meaning to them.
It's a wish list. It's a wish list. It's a wish list.
Mr. Uzair, we could go along with that.
If your lordship says that, then that takes care of all the problems.
Mr. Uzair,
these are not enforceable standards.
We could take this to be a wish list, and this could be used by the electorate for whatever subjective analysis whenever they want to. But the point is, we cannot attribute redundancy to the Constitution either.
Yes.
So that's the problem. We have to figure out what does this mean. So first of all, it is very clear to all of us now that there can be no declaration saying you're not sagacious.
There can be.
अब वो बताएं ना.
मैं इसीलिए तो कह रहा हूँ वो आप मुझे अगर sequentially चलने दें. That's how I have perceived things.
आपको हमने engage किया किसी ने कि यार ये मेरा मुखालिफ है, ठीक है, इसको डिस्क्वालीफाई करो. अब आप सूट बनाएंगे, क्या बनाएंगे जिसमें कहेंगे ये सजेशियस नहीं है, जरा बना दीजिए मुझे और प्रेयर मांग लीजिए उधर.
My lord, मैं क्योंकि ये नेगेटिव डिक्लेरेशन है,
ये कैसे मांगेंगे प्रेयर?
मैं प्लेन ड्राफ्ट करना तो प्रॉब्लम नहीं है, उसको प्रूव करना मुश्किल है.
नहीं बताए ना, मुझे ड्राफ्ट कर दे. मैं मुझसे तो ड्राफ्ट भी नहीं होगा.
My lord, as I said, जब डोनाल्ड रम्सफेल्ड ने कहा था ना, we'll jump off that bridge. When someone pays me for it, I'll think about it. Nobody has paid me to think about it.
जुडिशियल मैकेनिज्म क्या होगा ये बताया ना, क्योंकि समीउल्लाह केस में अगर आप पैरा 35 देखें, आखिरी 4 लाइनें लिखी हुई हैं. The judicial mechanism in Article 62(1)(f) of the Constitution grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate himself. What is the judicial mechanism?
वो नहीं दिया समीउल्लाह बलोच में.
इसमें लिखा है, समीउल्लाह से पढ़ रहा हूँ मैं.
नहीं दिया. उन्होंने
वो ये नहीं कह रहे नहीं दिया, वो कहते हैं कि बड़ा अच्छा जुडिशियल मैकेनिज्म दिया हुआ है इसके अंदर टू विंडिकेट द ऑनर ऑफ दैट पर्सन.
यस.
तो व्हाट इज द जुडिशियल मैकेनिज्म?
वो मल्टीपल, मैं यही अर्ज कर रहा हूँ जी, वो मल्टीपल मैकेनिज्म्स हैं. वो कैसे प्ले आउट करेंगे मैं वो बता रहा हूँ. पहली बात, जैसे मैंने कहा कि जी आप इलेक्शन प्रोसेस देख लेना जी, एंड टू एंड कहाँ पे ये चीज हो सकती है. आरओ के पास नहीं हो सकती. अगर कोई प्रायर डिक्लेरेशन नहीं है तो आरओ खुद ये डिक्लेरेशन कर रहे हैं.
आप रिपीट कर रहे हैं. देखिए हमें सिर्फ इतना बता दें, आरओ के पास भी पेश तो हो सकती है ना कोई डिक्लेरेशन. आप हमें बताएं डिक्लेरेशन आएगी कहाँ से?
माय लॉर्ड, वो डिक्लेरेशन
कहाँ से आएगी?
आर्टिकल 199 में
199 में, एक सेकेंड, 199 में you're only there to declare an act of a public functionary to be correct or incorrect or wrong, or right? How could you go ahead and declare a private person to be non-sagacious in 199?
My lord, why can't I file a writ of quo warranto against somebody holding a public office that he is not entitled to?
Fair enough. So he doesn't have the qualifications. Fine. चलो उसने कह दिया, हाई कोर्ट ने कहा कि आपके पास qualifications नहीं है, quo warranto में you cannot hold this seat. Does that mean he's not sagacious?
No, but I can then, the High Court can grant that declaration.
Where from? How? तो कहीं लिखा नहीं, उन्होंने तो सिर्फ सेट डिक्लेयर करना है कि ऑर्डर ठीक है गलत.
नहीं, बट अगर उसमें डिटर्मिनेशन ये होती है कि वो इसलिए
उज़ैर साहब
वो ऑनेस्ट नहीं है,
आप ये बारीकी
every time we pass an order in quo warranto, we must also go ahead and say this guy is not honest.
मतलब आप quo warranto में या किसी भी पिटीशन में,
आपने quo warranto कहा तो इसलिए
मैं किसी भी पिटीशन में वही आप ग्रांट करते हैं जो रिलीफ में मांगा होता है. कुसुआ बोलते तो आपके पास 199 में पावर नहीं है. तो अगर कोई
199 भी गाइडेड बाय दिस ना, 199 में मुख्तलिफ चीजें सर्चुरारी है, मैंडेमस है, वगैरह वगैरह. पहले तो आप पब्लिक फंक्शनरीज के एक्ट्स को सेट असाइड कर रहे हैं, या ठीक है, that's about it. We just declare that this action of the government or this public authority is incorrect. Now we don't go ahead and say that this private respondent in this case, or maybe even that public functionary who was doing this, who's passed this act, is dishonest or not a mean. So where is it coming from? So समझ ये आ रही है कि कॉन्स्टिट्यूशन कोर्ट्स में तो ये हो नहीं सकता, 42 में आप प्लेनरी कोर्ट से भी नहीं कर सकते. तो पहला सवाल तो ये है कि डिक्लेरेशन आएगी किधर से?
माय लॉर्ड, मेरा ख्याल, मेरी सबमिशन ये है कि आप 199 में भी कर सकते हैं, आप कोर्ट्स ऑफ प्लेनरी जुरिस्डिक्शन, और अगर मुझे एक्सप्लेन करने दें तो मैं
भंडारी साहब को वारंटो में कर सकते हैं.
सप्लीमेंट्री क्वेश्चन यहीं पर ये इसे फर्दर क्लियर करने के लिए, लेकिन वो इन लाइन विद आर्टिकल 62 होनी चाहिए एज पर योर आर्गुमेंट्स. माय लॉर्ड, जैसे सेल डेफिनेशन प्रीएम्पशन एक्ट में डिफरेंट, सेल ऑफ गुड्स एक्ट में डिफरेंट, ट्रांसफर ऑफ प्रॉपर्टी एक्ट में डिफरेंट. अब उसके अंदर जो भी डिक्री होगी वो फॉर स्पेसिफिक पर्पस जी. अब इसमें आर्टिकल 62 के तहत जब तक डिक्लेरेशन नहीं होगा, दैट विल नॉट बी इफेक्टिव.
बिल्कुल ठीक है, दैट्स व्हाट आई एम सेइंग.
कहां से आएगी?
Before the start of election, how a person can be declared that he is not entitled to contest election if even he was a public servant and there is a declaration of writ of quo warranto against him? How that declaration can be used?
My lord, Article 62. देखिए, आप quo warranto तो हर होल्डर ऑफ पब्लिक ऑफिस के पास हो सकती है ना.
जब पहले होल्ड कर लेगा, ये तो इलेक्शन, स्टार्ट ऑफ इलेक्शन है, he is going for
इलेक्शंस के quo warranto किसी पार्लियामेंटेरियन के खिलाफ भी तो हो सकती है ना.
अब होगा अगर 62 में ही
पब्लिक ऑफिस में आएगा तो रिमूवल होगी ना उसकी.
अभी तो ये एंटर करने के लिए
quo warranto का प्रिंसिपल तो आपको पता है ना कि how he is holding the public office, he shall be removed.
My lord, मेरी एक
But for that, he has to hold the public office.
मेरी एक सबमिशन है, with all due respect. My lord, I am here as an amicus. Let me give my views. If your lordships don't want to accept it, but
That's the best thing you said.
My lord, I feel I'm being cross-examined as if I'm
No, apologies.
I'm not a party.
Relax. Totally agree with you. Totally agree.
Clarity, just for clarity.
Probably turn around and say, I want to withdraw my amicus brief.
अच्छा चलिए, हम आपका पॉइंट, हम आपके अगला पॉइंट बताएं.
नहीं, अभी तो ये खत्म नहीं हुआ जी. अब आप लिख लें, आपसे नए से शुरू करें जी. नहीं सर, मैं यही जहाँ से सिलसिला टूटा था वही से शुरू करूंगा जी. मैं अर्ज ये कर रहा हूँ, दिस इज द पॉइंट. इट डिपेंड्स ऑन द नेचर ऑफ प्रोसीडिंग्स. ठीक, अब मैं अब थर्ड स्टेज पे आ जाते हैं. मैं लेट मी गो as per the structure of my own arguments. So, my lord, I say stage 2 was appellate tribunal